it exactly tallies. The stray ballots, even for that, it's actually 2 per polling stations, even if you looked at the scrutiny report. That gives you a figure of 92,000, the whole of the country, shared between the different ballot boxes. You cannot be able to know how the exact number of them, but that is the average. So if there's a variance of 10, 20,000, that's within, but anything way above that, that cannot be accounted for by the 92,000 becomes very problematic. And I think I have attached that, and if that could run, the court should look at that. So it's 2 per polling station, 92,000, which is accountable. So if there's a variance of 40,000, 50,000, then the court can question that. But anything within that range, that is within the normal range. The second question that Justice Ouko asked is, do you have any instances where voters walked into polling station and voted for presidential only? No, we don't have. The integrity of the ballot is very important. If someone comes into our polling station, we give him all the 6 ballot papers. He can do whatever we want with them, but he cannot go out with them. He can put it in the boxes, he can mark them, but he cannot. That's why we're able to account for either through the rejected or the stray ballot. So to the question that someone can vote for one candidate and leave the others, it's not true. It's actually, the regulations don't allow. It's a criminal offense for someone to get out with ballot papers or election material from the ballot box. The second question that has been asked is, Justice Ouko said the voter turnout, you say that there were 45,994 polling stations, out of which 46,299 polling stations were identified through KIMS. So only 235 were identified manually, out of which 6 did not have any election taking place because of violence, 229. I think the number you are interested is how many people voted manually, 86,889. 86,889. And the registered voters in those polling stations is 114,917. 114,917. 114,917. The interesting thing is we provided all the KIMS return. If you look at the affidavit of Michael Ouma, we provided all the KIMS returns. So you can check the KIMS returns as against how many people voted manually. Justice Ouko also asked a question. Justice Ouko asked the question that that is the number of the 86,889. Those are the people who voted manually. So the integrity of this process is very important because the other ones can be accounted for by the kits, right? The second question, Justice Ouko said, Omtata says 1,665,412 people curiously voted when the polls closed at 9. I think this is a faulty analysis, and you really have to understand how the kit works, right? So when you open the polling station, the kit sends a message that we have opened the polling station, we are ready for action. People pass through it, it sends automatic returns. It pings to the nearest network, sends automatic returns over the period of time. If it's not able to get the network, it will keep that information for the next 2 hours. Yeah, so that is how the number changes. The polling will close, but some kits will be sending the people, how many people went through, and it's only when we know when all the KIMS have transmitted and we know how many people have voted manually that you can be able to look at that, to look at it. So polling ends at 5 p.m. There are areas that voting commences on 6 a.m. on the next day. Some places in Eldas. KIMS reported happens once the network, once it has network, and it requests to connect. So I think it's a false analysis because he says at 5 p.m. we should have known the whole turnout. It's not true. KIMS will keep on giving that information. Justice Lenora asked the information about whether the Form 34C is captured in JPEG and what happens to it. I humbly want to donate a KIMS kit to the court, a training one for the court to see itself. I have given a dummy form, a training form 34A. I have also given the password. The courts can take the picture and actually see what happens. The kit takes the image, and it's on the image that actually the conversion happens on PDF. We don't do any JPEG, and there's a reason for that. In fact, if you look at it, when you are taking the image, it will ask you for the QR code, whether it is proper, it will ask you for the grayscaling, and you will see how we do it. And we do for JPEG, because all your phones take JPEG. We want to differentiate our image from the ubiquitous images of JPEG. So that one I want to, through the registrar, I want to donate to the court to see it, a live demo. Justice Wanjala asked the issue of turnout of 65.4. I want to tell this court, at paragraph 30 of the affidavit of the chairman, that clarification was sought and it was given. And the chairman, and there is a video to it actually, the chairman clarified, and he said the turnout is not 65.4, it is 64.6. In fact, you will see Martin Nyaga rushing to the chairman, telling him, the person who was in charge of the cumulative of the turnout, telling him, no, that is erroneous. So the number is 64.6 at the point where he made. Is turnout really important in the declaration? I want to tell this court, there is this fascination by the petitioners on turnout. We don't use turnout to determine the presidential election. I think that is the base to start from. The reason why we give turnout is a measure of transparency and integrity to know how many people pass through the kit. And the problem with it is a lot of people don't understand how these kits work. If you look at the numbers I gave on that screen, you will see, in fact, if you look at 2045 hours, 63.6 and 64.6, you will see that the total registered voters on 9th August 2045 is 21 million, under the KIMS 589,961. On 10th August is 21,926,565. If you deduct those numbers and you compare to the people who are actually identified by the kits, actually, the people who are identified by the kits is more than this number. And a lot of people will say, oh, why do we have more people who are registered in those stations than people voted? It happens. And because the relationship between the people who are identified in the kit and those total number of voters in those polling stations is not a linear relationship in this sense. So 9th August 2045, a kit will report 10 people. So we'll say 10 people have been identified in those kits, but the number of registered voters is 700. We will add in the total number of registered voters. You reached 10th August 240. That kit has already given its maximum registered voters in the original reporting. But people will keep on passing it. When another 20 people pass through, the kit will report 20 people have passed me through. So we will say the voters identified as the KIMS has increased. But we don't increase the registered voters in those polling stations because it is already reported. So the relationship is not one-to-one. And you have to understand, and this is the confusion that is coming, we have to understand, the only way you will know the total registered voters is when all the KIMS have reported. So when all the KIMS had reported, because this is a snapshot of that information in time, when all the KIMS had reported, the voter turnout was 64.7103. So what was remaining that time? Only the manual voters. How many? 86,899. So it's good to understand that, because if someone just looked at this information, you will come with all manner of confusion. So the kit will report, once one voter passed through the kit, we say one voter identified, but the column of registered in that policy we put 700. But the voters will keep on going through the kit. So as people go through the kit, we'll keep on increasing the voters identified in that kit, but the number of registered voters will remain constant. The issue of the Venezuelans, they were involved in deployment of infrastructure and the servers platform, where they did not have any access to the RTS. Look at the affidavit of Michael Ouma. Look at the affidavit of Hilda Kavongo. It actually shows the kind of rights they had. There was no unauthorized access, and in fact, the scrutiny report will bear that out. Did the postponement of elections in those counties only affect presidential voter turnout? I have indicated that is a hypothesis that has been laid out before the court. It is not borne out by the data. In fact, the voter turnout was comparatively the same. If there's no agent, Justice Mulu asked if there's no agent, what happens? The integrity, the processes that we have in terms of the KIMS return, in terms of the portal, even if there's no agent, we can actually confirm what happened. So it's not the role of even if someone said I did not have an agent, but my votes have been tampered with, we can be able to find out. Demonstrate, I have go to the last page. In the 40 seconds, Madam CJ, I can demonstrate that. If you look at that form, that is a form, the agent copy. If you look at the second last one, where it starts from demonstrate 34A, please. So look at that form. So side by side, it's the agent copy and what is in the portal. We have marked all the places that what is wrong with that form. What is wrong with that form? If you look at the elevation of the camera, same. If you look at the IBC logo in the background, both images, same. If you look at the exact paper fold in the bottom left corner of both images, same. The image is brightened to show that it has undergone editing. That's the top left is dark. The agent copy is in JPEG. The form is uploaded on our form is uploaded on the portal 10th of August 2022 at 2 days later. And we have put that in our affidavit, actually. You can check all the edits.
On July 4th, 2018,
sorry,
after
Council,
the Senate
you are not being recorded, but we suggest that you take the next 2 minutes and finish. Please put the machine back. You're about the end, right?
Yes, I am to the question that Madam Chief Justice and the President of the Court asked. I gave to the 185, yeah. If you can go back.
We'll give you 5 minutes,
Yes.
see what you can do with it.
Yes, yeah, thank you so much, Madam C. So what we did is we just took the form they provided us and we juxtaposed as against what we have. And we've marked all the places what is wrong with that form. And what is wrong with that form? If you look at the QR code, up on the left, on the right, and also on the left, the QR code, it's cropped similarly in both pictures. The IEBC logo underneath the document coincides with what was the pressing officer. It's actually an impossibility. I've given you a form to take a picture, and what you are producing me is actually underneath the logo of the document, the IEBC logo that the presiding officer was using. So I've given you your form, you're taking your picture for your agent, and you're using the same that the IEBC PO was using. Both photos are taken from the same elevation. I believe the court has ICT experts, and in fact, you don't need an expert to look at this. Look, the margins cropping are the same, which is really amazing. Look at the margin cropping for both of them. And there's no any other conclusion. What people were doing is that you will download, because there's no way you can be able to get our forms are different, and this form has gone through many processes from the polling station, county tallying, constituency tallying center. So the forms are ubiquitously available. They are available everywhere. The only way you can be able to do anything about it is you have to download our form and try to do tamper with it, what the agents in this case were doing. If you can go to the second one. This is the one I was describing. In fact, this one has, it even has the timestamp of their form, JPEG. We don't do JPEG. This form was relayed to them 2 days later. The elevation of the camera. And I have noted all the things that are wrong, the exact same fold. It's an impossibility. I mean, you have 41 polling stations all over the country, and the form they are giving is at the same elevation as what we have given. The picture that our PO took on the background of the Kim's kit is the same. And you can tell, and the reason why we were saying that it's an impossibility is because there's nothing else you can change from those forms. You cannot change the signature of the agents. It's an impossibility. The only thing you can change is the tallying. You can try changing to JPEG and try to amend the tallying. And that is really important. That is the crux of this matter, and the court has to look at that and actually make a finding. I will try to also, to Justice Ouko's question about the stray ballots. I just want to mention that the court report bears out the assertion of the IEBC. If you look at the report that was done relating to the stray ballots, I went through the court report and actually tallied the stray ballots. It is 2 per polling station. If you project this to the whole country, there will almost 90,000 stray ballots. And the way you account for stray ballots is they are put in the polling day diary, PSD. I have provided the polling day diary for 2 of the constituencies to just give the court comfort that as IEBC we can account for each and every ballot. To the question that has been asked by Justice Wanjala on the turnout, a clarification was given, and this is the assertion of the petitioners. They are saying, we are not interested in the clarification given by the chairman. We are going to take that turnout of 65.4 as against the total registered voters, okay? Then come to the conclusion that there are votes that are unaccounted for. And we are telling him that is not how we do it. Okay? Turnouts, we give the number of people who either have passed through that kit at a snapshot. Okay? And there's nothing much about it. The declaration is made on the actual physical ballots that we count. We count the physical ballots. After counting the physical ballots, we tally it. Madam DCJ asked about the rejected ballots, whether they are different from the rejected. So the way we calculate turnout refers to the number of people who have passed through that polling station in the 46,229 polling station in the Republic. We have not even reached the issue of rejected ballots or anything. It's how many people appeared that day. So we have a number. Then we do the counting. After counting, we get rejected ballots. So how do we determine 50 plus 1? We will say, okay, what are the total votes cast? And we will refer to the 2013 and 2017 decision of this court that said rejected ballots are not a choice of preference and the same have to be removed. So the idea that turnout is affected by rejected ballots or doesn't matter, it's just a measure of transparency. And you have to understand how the reporting of the KIMS happens for you to be able to do. We only give what we can at the time, and we'll keep on doing that. With those
Thank you, Councillor. You're not even being heard. But thank you for answering our questions. On the kit, please deal with the registrar of the court. Thank you for your assistance. Your time is up.
And thank you. And the slides are from our videos. They are available for clarification to the court. Thank you.
My lady, I do not know whether you can give me 2 minutes to respond to Lady Justice Jokindong.
You're not helping me to do my day's work very nicely.
I'm sorry.
But 2 minutes would mean 2 minutes.
Yes, please.
So that you don't go away saying you are not heard.
Thank you very much, Deputy Chief Justice. The Honorable Justice Jokindong wanted to know from me of my personal experience as a draftsman of the original Constitution, what our intentions were when we created independent commissions. And my simple, straightforward answer is we were trying to create greater autonomy and functional independence. You will recall elections, for example, were under the Attorney General's office and were under the hands of a person called the Supervisor of Elections. And that had been not very successful. What did we achieve? The one thing we achieved is that we created independent commissions that do not function in the same way. For example, this commission, the Electoral Commission, the chairman has executive authority. because this is one of the very few commissions where the commissioners themselves do some actual work. This is very different from EACC. EACC, the chairmanship is not executive, and the commissioners do not do executive work. They cannot determine to charge anybody or to investigate anybody. That is a work done by management. Here, as we have seen, this commission is extremely hands-on, and for that very reason, its chairman has executive power. It is very similar, Milady, to the JSC, the Judicial Service Commission, which in theory is a corporate body. In day-to-day functioning, the Chief Justice has executive authority and makes many, many decisions in the name of the JSC, as it should be, because it couldn't be run in any other way. Thank you.
We thank you, the Honorable, the AG Senior Counsel. Thank you very much. At this juncture, I return this to the Judge President to lead the proceedings.
Yes. Yes, thank you for that session. We are really mindful of the time today because we wanted to finish these proceedings at least by midday. We had allocated the petitioners, the main petitioners, 1 hour to do the rejoinder, and then the other petitioners were allocated 15 minutes. So this is the time now for the main petitioners, the team led by Senior Counsel Honorable Rengo.
My Lady, the Chief Justice, before the main petitioners commenced their response,
yes,
there were issues raised by the bench yesterday on which we are requested to provide answers today. At what stage will we be able to do that?
I think it is now. We must have forgotten you.
Thank you, Madam. Just give me 1 minute, I'll get my notes.
Can we give you 5 minutes to do that? I remember it was like 1 or 2 questions which were directed to you.
Madam, the dilemma I have is that there were about 3 questions raised,
yes,
which I should respond to. But if you may recall, you had also permitted the advocates for His Excellency the Vice President to respond to the application by the Chief of Civil Service, Mr.
yes,
Kenywa.
That is correct.
And they did that, and we didn't have an opportunity to comment on their response at all. So I will try to be very, very, as usual, very quick and respond in summary, but I will need about 10 minutes.
Okay.
And my learned friend, Mr. Gatia, Senior Counsel, also tells me he has a request to make. Thank you.
Madam Chief Justice, you recall yesterday how gracious I was. I donated 32 minutes to court.
Are you claiming it back?
No. No, I will not do that because the court has work to do. All that I request is 5 minutes, nothing more than 5 minutes of your time. We are doing quite well this morning. Thank you so much. I don't know who will go first, whether it's my senior or ourselves.
I think you can go first.
Okay.
Chief Justice and Deputy Chief Justice, members of the Supreme Court, just to point out that there were specific questions that were addressed. For example, to counsel acting for the 4 commissioners. And we would like to know at what point we are expected to respond to those questions.
after the petition.
According to two sources familiar with the matter speaking to Reuters. They confirmed Russian media reports that Ravil Maganov plunged to his death. But the
Top Russian oil official falls to death from hospital window sources. Two sources say oil boss fell to his death from window. Company says he died after serious illness. Latest in series of sudden unexplained
which
deaths.
We thought we would react to before we make our rejoinder. And I thought yesterday you had clearly stated that we'd have 30 minutes. We had about 27 questions. Are we at liberty to proceed to answer those questions right away?
Sorry, Senior Counsel Lengo, you have 1 hour to respond, but I hear you saying you need more than 1 hour because of answering the questions. And therefore, you're asking for another 30 minutes.
With a little bonus.
We can see what we can do with 1 hour. If you extend maybe 15 minutes.
It would not be enough. There's a very important question which just...
It's all right, because even the time we are wasting now, you could be answering.
Yeah, so
Yes.
in the 30
Just asking you to be kind, because we really have to get to the real business of writing the judgment.
Thank you.
And we don't have much time.
In the 30 minutes that we'll be answering those questions,
yes,
my lady and my lords, you'll be addressed by my learned friend, Mr. Otiende Amolo, particularly on the question of turnout, which was asked by Justice Wanjala, and Firoz Norji, Senior Counsel, Paul Mwangi, and Ms. Julie Soweto will address you in those 30 minutes. And I invite Senior Counsel Otiende Amolo to address you on the first question.
yes.
Not yet.
Not yet. Not yet. Yes. Senior Counsel Oraro, please, or is it Gatia?
My senior is beckoning my team. Do you allow us?
Yes.
Thank you. Professor,
5 minutes.
Chief Justice, Deputy Chief Justice, distinguished judges of the Supreme Court. Actually 3 questions were asked that are relevant to our submissions yesterday, paraphrased as follows. 1, if the National Security Advisory Council 4 knew the results before they went there, and 2, why would the result not be announced the next day to build consensus? And 4, what would be the effect of the non-involvement of the 4 commissioners in the verification and tallying vis-a-vis Article 138(3)(c? Our response is as follows. 1, it is our submission that all factors point to an inescapable conclusion that the 4 members of the National Security Advisory Council, by the time they went to the Bomas of Kenya National Tallying Center, and by the time the head of public service placed a call on the returning officer of the presidential election, by that time they knew. And this is our evidence.
After Lukoil demanded
by the morning of the 15th, letters had been issued by the returning officer of the presidential election, Mr. Chebukati, to all the presidential candidates and members of their family to be at the National Tallying Center for the declaration of results at 3 p.m. on that day. And my client already had received that invitation. I believe the other presidential candidates had those letters. And therefore, they knew by the time these state officers went to the National Tallying Center, they knew that the verification tallying had been completed and what was pending was the declaration of the final result. It is our submission, Chief Justice, distinguished judges of the Supreme Court, that these four went to the National Tallying Center not for any other reason, but to try to interfere with the declaration of results and thereby try to alter the sovereign will of the people of Kenya, which had already been verified and tallied in accordance with Article 138(3)(c). 2, it is our response that the results could not be announced the following day because, according to the affidavit of the chairperson of the commission, and I'm using the word chairperson on advice by Justice Ndungu, which I agree with entirely, that by that time, it was not possible for any form of consensus, because then the follow-up question was, I think, from Justice Lenaola, why, for example, the returning officer would not have waited for an extra day, which he had, to build consensus on the 4 walk-away commissioners. It was not possible. It was very clear that the intention was to try and veto the will of the people, and therefore the chairman had to declare those results. Number 3, the 4 who left, also, their colleagues had been injured. And so the chairman had, in our view, make the announcement that day because of the gravity of the situation. Finally, the question that this court ought to ask itself is whether the working away of 4 commissioners at the tail end of a process which they have admitted was complete, except the declaration, can veto the sovereign will of the people of Kenya. Can the walking away of commissioners at the tail end of a process they have been involved in be the basis of vetoing the right to franchise in Article 38 of the Constitution, which is the expression of the voter? Thank you, and we prayerfully submit.
Chief Justice, my lords, Deputy Chief Justice, Lady Chief Justice, I'll begin with the question which was asked by Justice Lenaola, and that is, what orders are we seeking? The orders we are seeking is for this honorable court to dismiss the allegation by the second respondent on oath, which have not been accompanied with sufficient level of evidence to justify proof beyond reasonable doubt as required by the Constitution and as determined by this court in advance. And that evidence is beyond the political statements which have been made by my learned friend, Professor Kindiki, just a few minutes ago, and which have never been put on record. On the issue of Rule 87.3, my view and my humble submission is that rule, contrary to the provisions of Section 39 of the Elections Act, and Article 183(3)(c) is the only regulatory framework which confers those powers which have been reserved for the Commission and grants them to the chairman. It is contrary to the Act, it is unconstitutional, contrary to the Constitution, and that was so observed in the case of Maina. Now, there was a question raised by Justice Dr. Wanjala, and you queried whether NSC would have gone to influence the alterations of results without knowing the results. My learned friend, who has just appeared, exhorts that the results were known because invitations had been sent out and the letter had been sent out. To the contrary, the evidence before you by the chairman was that he had gone to tally, to obtain the final tally only after he had met the commission, and that is found at paragraph 676 of his affidavit, where he says that after the NSAC team had left, the Commission Secretary, Chief Executive Officer, who was also the alternate team leader of the tallying center, Marjan Hussein, walked into the boardroom. Yeah. The purpose of the meeting was to receive the final tally of the results of the presidential elections before he could proceed to declare. And it is only thereafter that the results were handed to the commissioners and they walked out. So that even by the admission of the chairman, he was not aware of the results until after the NSAC team had left. Now, the Deputy Chief Justice asked about the effect of NSAC on the independence of IEBC. Your Ladyship, NSAC is a body comprised of all the heads of the security organs in this country, the head of civil service, the representative of Attorney General, and other heads in the government. Its purpose is to receive all the information on national security and give advice, not act. But even if they are of the view that it is insecure to be in this court at this time, it is the NSC who will give advice to the judiciary. And that is not an interference with the independence. And we have to take their role in the context that these 4 members of the NSAC were co-opted by the bigger body. They were not there on their own account, which has led to them now being vilified for undertaking an official duty they were requested to undertake. I had shouts from another friend on behalf of His Excellency, the Deputy President, of crucify them. In fact, this has indeed led to tweets today, and there are many, to various members of the NSAC telling them we shall revisit. This is what this type of allegation brings, and that is why I humbly request this court to look at the nature of the allegation, the burden on the people who are making the allegation, and dismiss them if there is no proof, and in my humble submission, there is no proof, so that we discourage this political vilification on officers conducting their official duties. Let's be careful, and I humbly request, particularly my learned colleagues, on what we wish for this country. Let us not wish mob justice to be the arena of operations whenever various functionaries are discharging their duties. Let politicians do politics, but let them leave professionalism to those who are engaged in various areas. In fact, since this process started, there has been a lot of vilification on the judges, on the parties appearing. In fact, tweeting has been the norm on discussing this issue instead of looking at it soberly. We can't stop tweeting. They are entitled to, but we can't bring it to this court. That's my humble submission. I beg that these allegations be dismissed with the contempt they deserve.
Yes.
My learned friend, Mr. Ngatia, requests for donation of the 2 minutes to him, but I really would wish not to be so gratuitous.
Thank you. Madam Chief Justice, if you may allow me, I did not put one of our lawyers on record, Mr. Donald Kipkorir, who is not in court because of the sitting arrangements. But to come to the business before us, in answer to the questions, 4 of us will deal with all the questions that were asked by the court, beginning with my learned friend, Mr. Paul Mwangi.
Madam Chief Justice, Madam Lady Deputy Chief Justice, my lords, my ladies, I have 9 questions which I'll tackle very first. What I have done is I have classified it into topics because they were across the board. The first is the relevance of rejected votes in the counts of the election. This is a matter that we have asked the court both in 2013 and 2017 to relook. We wish to resubmit as we resubmitted the 2 times, and to say that it is still our position that people who come out to vote, whether their vote is counted or not, are coming out to make a stand on the issue, and whether either due to technicality or other reason their vote is not counted, they must be not treated as those who stayed at home. They are people who came to express an opinion on how they want to be led, but for various reasons their vote was not counted. But the fact that they appeared should be taken into account, so that you would consider their votes whether they are rejected, and even if they are called stray ballots, should also be considered in that sum. The second question was regarding the scientific whether there are any scientific studies regarding the nexus of elections in a postponement. We have seen, unfortunately, we could not tender any further documents of this, but there are very many theories in political science, one of which we came across with the contagion theory, that elections affect each other. People come out to vote for various reasons, and especially when you're dealing with elections of a national level and a devolved level, there are very many considerations that would make somebody want to come to make a decision on a devolved government or a national government and not necessarily care about the other. But one of the things that we also must consider in Kenya's political culture is that in Kenya we do have 6-piece kind of campaigns, and that people come out to campaign together as teams, trying to win across the board on all the seats. And that when you disenfranchise one, when you stop one election, that means you demobilize part of the political infrastructure that is laid out for that. And lastly, on this point, we want the court also to consider that, at least in respect of Mombasa, And our evidence has shown that there was an order from the Mombasa High Court that has stopped the printing of these ballots, and that was disobeyed. There was also a promise that had been made by the chairman that he will not print, and he went against that too. And lastly, that it was announced on the last minute in that night. The third issue was what elements of Section 80 of the Elections Act we consider necessary in the face of the fact that we are also impeached the process. Apart from the elements that are laid out themselves in Section 80, which is that upon a recount, the person should have been a winner, and that the person should be found not to have committed any electoral offense. In our submission, we wish to add that first, the test should be whether the petitioner is culpable for any of the wrongdoings that is complained of. Secondly, whether the petitioner benefited from any of the wrongdoings that are complained of. And thirdly, that after whether it is a recount or a retally, the petitioner appears to have won the elections or has won the election. Those would be the tests that we would add to what is stated in Section 80. In respect of the question of image on the KIMS, the evidence that has been shown also even from the Commission is that the images are taken on a JPEG format, and the idea of the law of electronic transmission was that that image must appear as it is on the other end. The issue here is that there appears to be a place at which that format was changed. No reason has been given why that format was changed, so that it can go to any other format. But also to add that through one of the most popular applications today in Kenya is WhatsApp, and nobody changes. We get a lot of images as original as they are, as colored as they are, in the hundreds on an everyday basis. And I do not think there is any justification why an image taken on a JPEG on a KIMS kit cannot appear in the same format throughout the electoral process. The other question was in respect of the evidence, whether the 4 commissioners participated and what that meant. I would ask the court to look at the annexures that are put as MWK3 in the affidavit of the second petitioner, Martha Karua. And in that flash disk, there are 2 incidences at the National Tallying Center. In one incident, Commissioner Justice Nyang'aya comes out to read the results of Kiambu Town constituency. After he reads the results, it turns out that the result he has read has overstated the votes of William Ruto by 10,000, and also that he has gone past 100% of the votes cast, and he is forced to have to come to reread the results. That shows the commissioner had not known what he was reading. The other video is that also of Juniera Cherele. Again, she is given results to read of Juja constituency with the same results, inflated votes for the respondent, and a more than 100% voter turnout. And again, the results have to be reread. That would leave it to the commissioners themselves to explain. The other issue is about the constitutionality of Regulation 87. Now, first, our position is that a regulation or any act that is unconstitutional does not need the order of the court to be nullified. It is already nullified by Article 2. And at any time, it remains a nullity ab initio. The second issue to consider is the duty of every person, not just the court, to defend the Constitution as required by Article 3. And the fact that this chairman, the chairman of the IEBC, is a person who has qualifications similar to be the Supreme Court judge. So it is him who has betrayed the Constitution. It is him who has seen a regulation which is so clearly unconstitutional, has refused to defend the Constitution, and instead feigned ignorance and purported to use an unconstitutional provision to exercise power. So on that basis, every action that is done on the basis of that regulation is itself unconstitutional. The other question was regarding why the 4 commissioners did not raise issues to the end. Again, that we will leave for the commissioners to decide, but we can profile 3 theories. One is the issue of the 89th minute penalty, that if you participate in a game and the wrong penalty is given on the 89th minute, you cannot be asked, why did you play all along? Sometimes it is the 89th minute penalty that shows the unfairness of the provision. It could be the last straw that broke the camel's back, or it could be a road to Damascus moment. In whichever fashion we look at it, it is an issue that is understandable. The other question is in regarding for if there were to be ordered an repeat election, who would conduct it? Would go back to Article 250, Subarticle 10, because the Constitution provides for positions of vice chairpersons of all commissions. But Article 250 does not lay out any roles that they're supposed to be undertaken by those vice chairpersons. Our position is that that provision is not empty, and it is meant to provide for succession plans in commissions in places where an emergency or situations such as this, where such a succession is necessary. But the second issue would also be that the court itself, in inherent powers, has the power to ensure that its orders are fully obeyed and fully executed. And in such a situation, the court would treat its order as an order that has to be executed and would have the inherent powers to make all such other orders that are necessary to ensure that those orders are executed in full. Before I go to my last issue, I want to comment on something that was said about no agents. And one of the issues this court was told is that it appears there's a jurisprudence that is being built that where an agent does not appear from the other side, then the opposing side has a right to steal or a right to commit fraud, or somehow excuses the IEBC from any duties because there was no agent. And in fact, one of the advocates likened, said that you must have agents in every place, and even likened to agents. I said they should be like your wife. I believe that is what was said. Apart from the fact that that statement is very sexist and insulting, not just to women, but even to constitutionalism, their courts must restate the duty of IEBC to protect the vote at all times in every place, and that it cannot pass the buck to parties when wrongs happen, and also must put the obligation on every contestant in an election that if you meet a place where there is no agent, it does not give you a right to steal the election in that place. The last issue, and I follow this up with what my learned friend Maha did, I want to show the courts a Form 34A from a place called Gasharaigo Primary School, and it is in Muranga, in Kangema constituency, in a ward called Murogo, in stream 2 of 2. And this document is overlaid over some documents, but look at the left-hand top corner. It is overlaid over a document written Jose, this is Jose Camargo. Jose Camargo is one of the Venezuelans that was arrested at the airport with charges of coming to interfere with the elections. He is one of the people that the last Mahat has said did not have access to the RTS. This form is in the official portal of IEBC. The question would be, was this document photographed by a presiding officer at Gasharaigo Primary School, sometimes possibly at 8 o'clock in the night? Or is it possible that this document has been photographed elsewhere in some office and uploaded? This, we ask the court to read the DCI report regarding Jose Camargo, and we believe, my lords, that these are the fingerprints of one of the suspects of the theft of this election. That is all.
Good morning, my ladies and my lords. I will pick up from where my learned colleague and senior Mr. Paul Mwangi has just left off. The court had asked that we demonstrate with examples in real time how the Form 34A was interfered with or could be interfered with. And I will do so showing you or using the IEBC's forms itself, straight from the IEBC, from the IEBC portal. My lords and my ladies, I will walk you back through the form that we have just showed you. I see that the court has laptops, which means you're tech savvy, and you can access the IBC portal right now. This is going to be a live demonstration, as the court asked that we do. I'm asking that we go to the forms portal in the IBC. We are projecting it up so that it's not said, because we have been accused of cooking things, forging things. We've been called many names. This is the IBC's own document. We're asking that you open on your own devices, but even as we show, Murang'a County. Kangema, Muguru, and Gasharaigo Primary School 02. This is live. My lords and my ladies, we have downloaded a Form 34A from the IBC portal. And I'd like the court to just scrutinize this form before we go to other details. From where I am, the stamp. The stamp. My lords and my ladies, is that the IEBC stamp? It's on the IBC portal, looking like it's been superimposed over another stamp. We have been asked to show how are the figures changed. The votes. Now, My lords and my ladies, if we look at the votes cast, the first figure on the form is for Raila Odinga, 55. It's followed by William Ruto, 260. It's followed by, I think that's Mwaure Waiga, 001. And the last is Wajakoya, 000. If we sum up the total votes, we get 316. The total votes cast according to this particular form is 321, different from what we have just seen. The rejected votes are 4, which means already by calculation there is a problem. But we'd like the court to look at the total number of registered voters. A close scrutiny of the form shows that the number was probably 455, and the 5 is actually similar to the figures written in the votes cast. But somebody or somehow that figure has been changed to make it look like 488. It is obvious to the naked eye when you look at that form. Now, when we go to now the bombshell itself, the top left-hand corner of the form, we were told by my colleague, Mr. Gumbo, there were no foreigners in this election. We were told the foreigners left before the 8th of August. We were told they did not even have access to maintain the server. This is on the 9th of August, and at the top left-hand corner there is the name of one of the Venezuelans, Jose Camargo. This is the person who decided the president-elect of the country. It is on the IEBC portal. It is live. How did that come there? What are you doing? This person is the one who was interfering with the forms. We are able to demonstrate, at least a crumb was left. By God's grace, we found something. We didn't make this up. We were told we forged these documents. Now, this is how, my lords, the staging was happening. This is how the changes were happening. This is on the 9th of August. We were told they were not there. I'm going to do, because of time,
with your permission, Your Ladyship.
I beg your pardon. In our petition,
you let her finish and then you tell us what it is they're responding to.
It relates to an objection to what she's doing, Your Ladyship.
No, let her finish.
And it's not the IEC.
My ladies, my lords, that name, Jose Camargo Gregorio, appears in our petition, and is also, that evidence is also found in the affidavit of the second petitioner, one of the people whom we complained about as having interfered in the election and who were told had no access. My lady, we're going to take you again on the same IBC Live portal to show how the staging was happened. and because of time, if we can go to Bungoma. We want to do it live, and we're doing it live on the IBC portal. My lady, we were told about the KIMS kit and how they work. The serialization of the numbers. We have been told that each of the 42,201 KIMS kits that were used in the election had their own unique KIMS kit ID and serial numbers. Bungoma County, Mount Elgon, Chesikaki, and Songoyiwa. We'll download the form. The nomenclature of the KIMS kit and the form is shown at the top on the address bar. And for purposes of time, my lady, what we're told, it will show you that that's a Form 34A. It will give you the serial code of the polling station from which that Form 34A relates. And then it will show you the KIMS kit serial number or ID. There'll be a date stamp and a time stamp. What I'd like the court to focus on is the serial number, and perhaps because I can't see from here, this is where I would have liked the court to have its own, but maybe if it can be. Do you have a roving mic? Now, the serial number on this particular form, my ladies and my lords, which I would have liked for the court to confirm for itself. If somebody there can, may I ask one of the court assistants to read for us the serial number as it is so that then I'm not accused of making up things?
That's all right. It doesn't change anything. Evelyn, could you read that?
The number that starts with F2, it's in the middle. Or can I read it myself?
I can't see it. The one on top?
Yes.
PR06.
No.
Sorry. F2.
My ladies and my lords, what would require is that you note down that number. We will compare it with another later.
It reads F23045-0M00204-133.
The time, please. It's right next on the date.
That one. The time is?
The date on which?
9th August 2022 at 1956.
We'll check another form. Nyeri? Nyeri Town? Gatitu, Morogoro, Thunguma Primary School, Stream 3. Can you read the serial number?
F230450 M00204133.
And the date and time, please?
9th August 2022 at 23:49.
My ladies and my lords, this is the same KIMS kit transmitting or sending results, one from Mount Elgon, 1,000 kilometers away from Nyeri town. 2 hours later, how is that possible? When each KIMS kit was supposed to have, each polling station had its own unique KIMS kit, which was supposed to transmit from its own unique IP address. Because of time, I cannot demonstrate the thousands of forms that we have identified with the same issue. My ladies and my lords, this is how the staging or the complaint that we raised happened. We did not give this court a fiction. What we gave the court happened. Now, staging, and as we have shown, the 11,000 polling stations that we had complained were staged were transmitted all from one IP address. Every KIMS kit was required to have its own unique IP address. The only way 11,000 KIMS kits or results can be transmitted from one IP address is if they were collected, and as probably my senior Paul Mwangi had. May I have, I beg your pardon, my time is up.
2 minutes. Yes, 2 minutes.
Yes. My ladies and my lords, the manner in which the election was stolen, the reason why staging was necessary was forms were intercepted like this. Whoever intercepted them then had time to decide which ones they could manipulate before uploading them and sending them to the IBC portal. The other reason that we know there was manipulation is because the original Form 34A is a colored form that should have appeared at the National Tallying Center if transmitted in one transaction as a colored form. All the forms that are on the IBC portal are in black and white. At what point were they altered from JPEG to PDF? When did that modification happen? And what other modification was done to the form? We submit to you that we have shown that not only was it possible, it did happen, and the fingerprints of those who interfered in the systems are still there. Thank you for your time. I don't know whether to be that generous. I donate the 29 seconds to the court. Thank you very much. At the insistence of my seniors.
May it please the court, my name is Kirago Kimani. My learned friend, Mr. Katua Kigen, had gotten the attention of the court, but was asked to wait until Ms. Soweto had completed her presentation. I would wish to respond to what she has just addressed you on, because this is new material, and would like to have direction.
Mr. Kirago?
Yes.
When I forget his name, Mahat was answering the questions, he did the same.
Yes.
He went through his PowerPoint.
That's correct.
To demonstrate.
That's correct.
How this staging was happening, because we asked that we be explained.
Yes.
How the forms were being captured in the hair and being changed. And he did that.
Yes.
Going back to what he had done.
Yes.
So what is new here?
What is different is this. You have a petitioner and you have rules that say how they are to present their case.
This was answering a question from court.
Yes. Where does the first respondent have an opportunity to address these matters? At what point in time does the first respondent get a hearing?
This was a question by the court to demonstrate how this was happening.
Yes.
What we do with the demonstration. Mr. Mahat on your side did demonstrate. They have demonstrated.
I appreciate what your ladyship is saying, but Mr. Mahat, with respect, is not on our side. He is a referee. My client was a candidate. We are not on the same side. We may be respondents, but he called this match, not for us, but is required by the Constitution.
Mr.
But anyway, the long and short of it, yes. The long and short, yes.
We are not going to give you time.
Much obliged.
Yes, thank you. Proceed with, there were responses from the other petitioners. And beginning with number one, the same order we followed.
Remove that one.
You have responded. So who was next? It was, I think, Senior Counsel Jan Mohammed was her client. The same order we followed so that we don't waste time. If you can't use the 15 minutes, please.
Your Ladyship, Madam Chief Justice. Your Ladyship, Madam Deputy Chief Justice. My lady and my lords, I was very generous in my opening, so I'm sure I'm going to be just as generous and patriotic as I am in my rejoinder.
Play a free
I had donated, I was the first one to donate 7 minutes in my opening.
Okay.
My lady, on behalf of the petitioner, in number one, that's the second petitioner, we had filed a rejoinder of the submissions after our original submissions. And my lady, the petitioner's case is very simple. All it was the petition was limited to a legal issue. It was the role of the commissioners vis-a-vis the chairperson.
I saw people murmuring, and I want to get this correct.
I'm sorry.
Is it that we should then, because I thought you had a response, you had any question to answer?
In fact, my lady, the question I'm going to be answering is actually the rejoinder as to the role, as the answer to the role.
For purposes of orderliness, because we are trying to get our proceedings as orderly as possible, then we can start with the rejoinder by the first petitioner, then the others will answer the questions with their rejoinder.
Because my actually rejoinder is the response to the question of what the role of the other commissioners was vis-a-vis the chairman and the commission. Okay. That's what my entire petition is based on.
So then we start with the main petition,
that's
their
fine.
Rejoinder, then we that's come fine. To you. I'm sorry about that.
That's no problem, my lady. I'll still donate my time.
Yes. Senior Counsel Olengo, it's your turn.
I'm just wondering, because if I heard the court correctly, there are some questions put to Mr. Umtata
They will respond with their rejoinder.
With a rejoinder?
Yes.
Oh, okay, then that's correct. In our rejoinder, Madam Chief Justice and the members of the court will have 4 in our team giving the rejoinder. Senior Counsel Firoz Norji, Senior Counsel Otiende Amolo, and Senior Counsel Philip Murgor, and I'll have 5 minutes at the end. Okay. But I'll begin with Senior Counsel Otiende Amolo.
If it may please your ladyship, this honorable court, I will be brief in this part. I will cover only 3 quick subjects, starting with the issue of the 50% plus 1. Your ladyship, this honorable court, may it be noted that the question of the voter turnout in this election is a moving target. It is a moving target depending on who's speaking and in what circumstances. If you look at the replying affidavit of the chairman, paragraph 30, as of 9th of August at 5 p.m., he says the turnout was 64.6%. That is an affidavit he's swearing way after the fact. The director of elections of that same date, at that same time, in paragraph 21, that is Moses Sunkuli, says it was 56.17 at that same time, looking at the same Kim's kit. It will be noted by this honorable court that at various times, the IBC gives different figures. At one time, it uses the figure of 65.4%. At another time, it uses the figure of 64.6%. It is our submission, my lords, my lady, that the premise upon which IBC proceeds is wrong, and that the reason for this moving target is so as to manipulate the question voter turnout, to come to a conclusion that the 9th respondent met the constitutional threshold when they didn't. I wish to submit, your ladyship, my lords, that Article 138 is very clear, and the total number of registered voters must be specified, and that is the denominator. The IBC did publish a gazette notice that confirms the exact number of registered voters and gives it as 22,120,458. In this court, using what they say is the turnout per the Kim's kit, the figure they are seeking to use is 22,005,541. We wish to submit, your ladyship, my lords, that that premise is problematic. The common denominator to be used is the voter turnout as published in the Gazette, not the voter turnout as per the Kim's kit, which ends up with a moving target. We wish to submit, your ladyship, my lords, that not only is it true that the target is moving, if you look at all the permutations, and this is in the supplementary affidavit of Dr. Edgar Otumba, if you take any of the scenarios and you use any of them, and we will submit, we have submitted this for ease of reference, because Dr. Otumba covers is between paragraph 5 and paragraph 30, and puts all those graphs. By whichever permutation, none of the candidates then achieves 50% plus 1. Whether you use, remove rejected votes, you add rejected votes, whatever permutation, and there are 7. We wish to submit, your ladyship, my lords, that you then need to come to the conclusion that even though they try to take time to tamper with the voter turnout, they do not achieve that target. The last point on that. Why is it wrong to use the vote turnout as per the so-called Kim's kit? Other than the fact that it's unlawful, it is also illogical. We have 46,229 polling stations. If you are to rely on the Kim's kit, The question here, and that's my third and last point, is really very simple. And it's a question that draws directly from Article 138(3)(c) of the Constitution. It is very clear, it is mandatory, that once results are received, the IEBC, not the chair, shall tally and shall verify, then shall declare results. If the IEBC as an institution has not tallied, has not verified, then there are no results to be declared. We wish to submit that at the end of this analysis, it is not a question of whether the chair is a hero or otherwise. It is a question of whether the chair did what was expected of them. It is not enough to say that there are certain regulations by the first respondent which they themselves made and now they wish to rely on to breach the express provisions of the Constitution. We wish to submit, Your Ladyship, that in accordance with Article 141, only if there's a result properly declared can you even move to challenge it. In this case, none was done. Your Ladyship, what the chair is inviting you to do is unconstitutional. This bench comprises eminent persons who are involved in the process of making the Constitution, as some of us on this other side. There's a good reason why we've created constitutional commissions and independent offices. If it was intended to create the chair as what was previously called the supervisor of election, there'd have been an independent office, like the Auditor General, Controller of Budget, like the DPP. But now the chair is inviting you to find that his is some sort of imperial chairmanship or chairpersonship in defiance of the Constitution. We wish to invite you not to accept that invitation to amend the Constitution belatedly. My lady, my lords, at the end of the day, the only question will be, did the chair act in accordance with the Constitution? Is it fair to invite you to find that the other commissioners do not matter? The chair of IBC is a first among equals, just like in this court. There are 7, just like the judges of this court. But the fact, Your Ladyship, you are the Chief Justice and you are the President of this court. Yet the Constitution would not allow you to exercise veto powers over the other colleagues. Why would the chair believe that he can have such powers over the other colleagues? Ultimately, my lords, Your Lady, it is the decision of the majority that must be the decision of the court. And similarly to the IEBC, as we are here today, the decision of the IEBC is that the match that was being played was stopped by the referee. If it was in court, it would be a mistrial. By their own admission, they have said that things happened which should not have happened, and therefore it was not complete. My lords, my lady, in 2017, this court made history by nullifying the first presidential election in this continent, and I think only the second known to me in the world. In this year, it is the IEBC that is making history. It is the first electoral body to concede that they did wrong. I want to submit, my ladies, my lords, that you cannot override that decision by IEBC itself because it's made by the majority. I wish to stop there for now. Thank you, my lord.
My Lady Chief Justice, members of the court, address the court firstly on the issue that in making your final decisions, in reviewing your own views, the views of the respondents, petitioners, parties who have addressed you, we would be praying for the prayers and orders that we have sought. And in doing this, may I first refer to the principle that would be applicable in approaching your decision and judgment. In this context, the court has heard today from my senior AG Emeritus, Honorable Gitu Muigai, in answer to your question, that it was the intention of the makers, it was the intention of the makers that the Commission should have an executive chairperson. That we have learned much by that, but that is not what we or they and your ladyships and lordships can proceed on. We have to proceed on what is in the Constitution. There is no provision in the Constitution for even if that were the intention, there is no intention shown to override any of the other commissioners or their views or their actions, or to change the Constitution's clear provisions of Article 138(3)(c). The tallying has to be done by the IBC. The verification has to be done by the IBC. The declaration decision has to be made by the IBC. And where there is a specific step to be taken in an executive fashion by the chairman, it's provided by 138(10). The declaration of the decision of the result will be made by the chairperson. Secondly, it is an important consideration. When yesterday the question arose of the two aspects. One, that although there was a further day still in hand, the chairperson rushed to judgment without the 27 constituency results because of the doctrine of necessity, said Counsel Professor Kindiki, in justification of this. The doctrine of necessity was not necessary at all. There was no crisis at that moment. They were, he has indicated, in great danger of their lives. But 20 minutes later, they were shaking hands with his client, and his client was shaking hands with a very able-bodied chairperson. Nobody left that hall in the imminent expectation of watching carnage and bodies lying all over the floor. No one. There were church people, 2 rows of church people. There were, and I am grateful to them, the choirs who had kept us not entertained only, but inspired through those hours and hours. There was no imminent danger. This continuous, they could not resist the temptation of showing a still photograph in order to show that there was a necessity. No, there was not. And it is very important to realize that we do not use these exaggerated criteria in order to come to a justification of plain wrong. Is it the issue is, was the Constitution being followed or not? And that is where the concentration has been lacking from the respondents. An important aspect of this, of bringing forward the doctrine of necessity, is that it is a very dangerous legal justification. It shows the need to bypass the constitutional justifications and arrive at a subjective, convenient, and self-serving justification. And it is dangerous because it has been used before by lawyers as eminent as Professor Kindiki. It has been used in Rhodesia after the UDI, Unilateral Declaration of Independence, to hang freedom fighters who were resisting the Universal Declaration of Independence. And the doctrine of necessity goes one step forward to say that if power has been usurped, taken, otherwise than in compliance with the Constitution, the courts should still recognize the usurpation of power. And they were hung, not only in Rhodesia, but in Pakistan. After a coup, their courts accepted that the doctrine of necessity, the acknowledgement of what was shown to be the new Grundnorm, would have to be acknowledged. And so the coup was all right. And so my learned friend, the professor, is saying, you too must acknowledge. And what does the doctrine of necessity always acknowledge? It acknowledges wrongful taking of power. And the Grundnorm is thereby changed, and therefore the court must accept it. So they're basically saying to you, recognize there was need, recognize that the chairperson did this out of necessity, and therefore it has to be accepted. It was done in Nazi Germany. That's where the Grundnorm comes from. And therefore, we submit not only that you should reject it, but you should condemn the attempted use of it so that it can be used here now in this innocuous, apparently innocuous moment in a case in a hall full of lawyers and judges. But it is a very dangerous thing, not only historically, but because Professor Kindiki revealed, perhaps unknowingly, that we now know that the doctrine of necessity has been discussed in their private thinking and now is brought here publicly. And when there is, next time, there doesn't have to be a chair and 3 people and 2 policemen clearing the chaos. Next time, when there is a manufactured group assaulting another group of 50, 100, 200 people, who will get up and say, we have taken power as an act of necessity? Because our attempt to do so at Bomas, to establish a new government not in compliance with the Constitution, failed, as it should fail. But now, with the doctrine of necessity, we are there. And we will take on anybody who says that we are doing anything wrong, because the doctrine of necessity requires that we restore peace and order and move on. And then when we bring the matter to court, learned Professor Kindiki will be here to say, I will now refer to the case of Mandus Butiro, South Rhodesian law reports, and say, here it is. Here is Pakistan. Here is the case from Uganda after the Uganda coup, applying the same thing. And we say, this is the prophecy that is put forward now in their thinking, shown unwittingly, I think, by Professor Kindiki, and placed before the people of Kenya. We say, not only reject it, but reject it consciously, so that the precedent is not of a submission which failed, but a precedent of the Supreme Court of our land rejecting this ever for use in Kenya. So what should we be using? I'm happy to say that, again, from the respondent's side, I draw some inspiration. And that is from my learned friend, Senior Counsel Fred Gatia. My learned friend, both learned and friend, put forward before the court, and he said, let us get at the substantive truths. He put forward a criteria completely different from Professor Kindiki. And I'm happy to say, yes, let's do that. So we put to you, when we put forward the manipulated postponement of Mombasa and Kakamega, we showed to the court that the Gazette notice, the power which Mr. Chabukati used, was illegal, because in the Gazette notice he lied and put forward just half of what the power he has needs to meet. And so, when we put these forward, they could not reply, but those who attempted the reply said, but look at this. This is his power, this is his this is his section here, and he's an executive, he's this. But Senior Counsel Gatia's principle was a more important and relevant approach. So we say, what is the substantive truth behind the postponement, behind the lying Gazette notice, before the self-serving amendment or of the Regulation 67 by which he changed, this chairperson changed, or got changed, the constitutional provision that the papers 34A and B received at Bomas must be dealt with by the IBC Commission. Instead, he changed it to the returning officer. It has been pointed out there is no such office, and he put it there. What is the substantive truth behind this? What is the substantive truth behind the fact that despite several orders from you, the server has not been fully opened? What is the substantive truth behind the fact that this is not the first time this chairperson has disobeyed the court? What is the substantive truth of the absence from his behavior of any reference to Article 10? Article 10 is values. They are national values. And the beauty of our Constitution is that it is not only a manual of government. Finance will be dealt with this way, so-and-so will be appointed that way, he can resign or he has to be removed or this or that. Each and every chapter has its specific values set out therein. 81, 86, and at no point in the whole of the day spent and today, this morning, has there been any reference by the respondents' counsel or supporters, or by any reference to instructions, that these values we kept in mind. This is how we advance. By postponing Kakamega, this is the value we advanced. By not checking the wrong printing of the ballot paper, how did we advance Article 10? There is even one more duty on them, on the chairperson. It is that it is part of the duty of the chairperson, the whole commission, to ensure the removal of any impediments to the functioning and the purpose and the aims of the commission. They have breached even that, even the passive duty. And we say, yes, that is what we look at, the substantive truth of all these things. And in that, once you do this, it is clear that this is an election which is brazenly, shamefacedly, without remorse, saying we did right when we were doing wrong. You do what you can about it. Nothing happened to me in 2017 personally. And it is all right. We say no, and we say to the court that not only is the petition, we pray, to succeed, but very importantly, if you find that there is violation of the Constitution by the chairperson, it is not necessary for the court to take any steps to his removal. there is a constitutional position. Thank you. There is a constitutional process to remove him, and there is no need for the court. But there is an important duty on the court that if you find a serious violation, and we submit there are all these serious violations, it is important that the court makes a finding. We hold that, or we find that the chairperson violated this article or that value, and that those are set out. We pray accordingly. Thank you.
Having just come in, good morning, Your Ladyships and my Lords. I'll take as short as possible. In order not to repeat, I will be very brief. Arising from the questions asked by the court, I'd just like to put it on record and of course, in particular, the very rapid submissions of my learned colleague, Mr. Mahat. Sometimes you miss exactly what he's saying, but I picked out that he did not at all mention how the system for the KIMS kit was converted to the provision of PDF. The tender document, and we have provided evidence of it, did provide that the KIMS kit would transmit a compressed color photograph image using a compression technique that is in compliance with JPEG. That requirement was never changed unless it was changed quietly, fraudulently, and with the sole intention of rigging the just concluded presidential election. My learned friend, again, Mr. Mahat, challenged everybody that if there was a program that could convert a PDF document or could edit a PDF document, they would buy it. They would buy it. I suppose he meant the IEBC. I, at that point, did ask whether he's an employee of the IEBC, but I was assured he was not. I would like to state for the record that the software for editing a PDF document is available free of charge and can be downloaded by him or the IEBC. And we would request that millions of public money not be used to do this. But the programs that exist for editing a PDF document include